other appointee of Nanado, they both dissented, describing the decision of the majority as just hiding under injunction to do what the Supreme Court did not have jurisdiction to do. How different is what the dissenting opinion posited from what the Domahini stated? That if he were a member of that panel, he was going to side with the likes of Agnes Doji and Namigache, who are all appointees of Nanado. So what crime has he committed, or what prejudicial and contemptuous statement would that be if he made that statement? The second thing he said was that, as a matter of urgency, he thinks that the Attorney General should enter a nolle prosequi to discontinue the case. Now, nolle prosequi are special powers of the Attorney General and Attorney General alone to discontinue criminal actions instituted against people, not because they are either guilty or not guilty, but for varied reasons best known to the Attorney General. And let me take you through a journey. You remember that when the Delta forces attacked the judge in the court, the Attorney General entered nolle prosequi in respect of that case. You remember, you were in Ghana. You remember that when sympathizers of the NPP, including one Siedu Imba, were arrested in respect of kidnapping of the Canadian girls in Ghana, this Attorney General, then as Deputy Attorney General, entered nolle prosequi in respect of those people. In the Gregory Afoko case, after they have gone through trial and the jury was just about giving their verdict, the Attorney General entered a nolle prosequi. So what the Domahini is saying is not inviting the Attorney General to do something which he hasn't done before. The Domahini is saying that in instances where people did not deserve to benefit from the powers of the Attorney General in respect of nolle prosequi, you gladly entered one. So why should you not do that? And you see, this justifications matter goes beyond NDC MPP. This is a man who has been hounded out of office, albeit through the court, or if you like, legal means. We went to Asin North for an election. The whole government machinery, by way of the president, the vice president, the chief of staff, ministers of state. In fact, there was a directive that all CU ministers, deputy ministers, and every appointee of this government had to be in Asin North to campaign. We have seen the videos of vote buying. We have seen the videos of sharing money. We have seen the videos of the government engaging in sudden developmental agenda for the people of Asin North. And yet, over 4,500 plus people said that we want Mr. Jachikwesun to represent us. We didn't make a mistake. We stand by what we did in 2020. And so, especially when he did not commit a crime. Mr. Kwesi is being charged for perjury. Perjury means that you willingly would have deceived the public officer or lied under oath. Mr. Kwesi never lied under oath. In fact, he never said that he had not renounced his citizenship. He was given a hearing. He presented evidence. The Electoral Commission made a ruling on his case and he contested. So, by hook or crook, legally, if Mr. Kwesi was your client and he came to you, you were confident to advise him that no offense of perjury had been committed. Except these days, the law has been turned upside down and is being practiced subject to the whims and caprices of Godfrey Dami, who thinks that the office of Attorney General is his personal office and he has persecutorial powers rather than prosecutorial powers. And if he didn't like someone, he will use the powers to prosecute to just come after the person. So the Domain is saying that as a person who is a lawyer, as a person who is a chief, as a person who has observed the circumstances under which all these things have happened, if the Attorney General cared about the people of Asin North, if the Attorney General cared about the democracy we are enjoying, and for that matter, its soundness, then as a matter of urgency, he also entered nolle prosequi. Because the people of Asin North have shown you that if the man were in prison or otherwise, we will still vote for him. In fact, some 7 days of the election, that Attorney General made an oral application in court for trial to continue every day. And so Mr. Kwesi will leave the constituency and come to Accra in the morning and come to the constituency in the evening and campaign. And yet, despite these, the people said, we still want him. What else does he need to show that he needs to enter a nolle prosequi? And the Domahin is not the first person to say their own member, who was a former Attorney General, who has occupied the position that this Attorney General is occupying, has also said that a nolle prosequi should be entered. Senior lawyers like Martin Pebu, Nana Jantwa, the male one, and many people have said that this is a needless prosecution, just calculated to tarnish the image, just calculated to deny the people of Asin North some representation. And so there is absolutely nothing wrong. The only thing that is wrong with this statement is that you have a government that does not like people who are courageous, people who are confident, people who cannot be bought or intimidated, speaking truth to power. That they don't like. Otherwise, I don't see anything wrong with what the Domahine said. And it should be noted that this is not the only time the Domahine is making his views public on some matters which gain public prominence. So he's been very consistent in his position on how certain things in the public should be done. Except this time, I mean, he has just hurt the ego of the president and the Attorney General, because his position seems to be contrary to their position. Otherwise, there is absolutely nothing wrong.
But the suggestion has also been made that the using the basis of an election to make such an appeal is quite wrong. That prosecution should be done with or without favor. That when somebody is found to have broken the law, the person should be prosecuted. What do you think?
So for now, what law has Mr. Kwesi broken? For which reason he ought to be prosecuted? Now, let me make the point that before Mr. Kwesi submitted his nominations, and even after his election, the Supreme Court had not interpreted Article 94(2). And so, for all intents and purposes, it meant that that provision was vague. And many people believe that allegiance never meant citizenship. So if after you have now interpreted, the law is not applied retrospectively, because if at the time of filing his nomination and his election, allegiance did not mean citizenship, then you cannot say that I'm prosecuting you for something that at the time the Supreme Court had not interpreted and it was not clear. So what crime has he committed? Mr. Kwesi's case is a clear case of persecution. It's a clear case of government who is clutching onto straws because the very germane matters of the economy and bread and butter issues have defeated them. It's a clear case of people who think that they can win a certain seat and get majority, and by hook or crook, they have to latch onto something. Otherwise, Isn't the Tolan MP being accused of being convicted, and as an ex-convict, they ought not to be in Parliament? Why is the Attorney General not invoking with a matter of urgency his prosecutorial powers to go after the Tolan MP, who is a leader in the MPP? Or the Attorney General chooses who is handsome and who is not handsome to prosecute? What is the basis of the prosecution? It has no merit. It has no merit. It certainly cannot stand. And they themselves have seen. Indeed, their strategy was that if they were prosecuting Mr. Crayson or Honorable Crayson, he probably would give up the seat. They have attempted to bribe him. This is a man who refused to accept the bribe and said that I will represent the people of Asin North. And so this prosecution cannot be coming from a good place. It is their last resort, having attempted to bribe a man who is a man of integrity and will not take millions of cedis from government so government can constitute a majority and pass obnoxious laws, having refused to step down and leave to Canada, but is resolved to representing his people, and he loves his people so much. This was only the last straw that they had, and nobody can convince me that this is being done because somebody has broken any law.
But the majority leader says you in the NDC are the ones who are being selective. When it came to Adamu Sakande, he should go inside. But when it is now time for someone in your party to face the law, you are trying to say, no, it's persecution. Now, what is good for the gander must as well be good for the goose.
You know, when I hear people make that comparison, initially, because many people are not lawyers, I pardon them. And then I say that perhaps they don't have the benefit of studying what we call stare decisis or precedent. But I've heard a lot of lawyers in the MPP make the same argument. So now I am a bit constrained as to what to say. We said time and again that no lawyer worth his salt who has sat in the law class will compare the case of Adamu Sakande to what we have. And time and again, we said that is not the case. In the case of Adamu Sakande, even after his election, he held 3 citizenships. He had not even taken any steps to renounce one, so that you would say that intention will be negated. In fact, at this trial, evidence was led to show that consistently he traveled on different passports when it was most convenient for him. We were talking about a man who has renounced his citizenship more than a year to an election. And the only basis is that he did not have the certificate of renunciation. Not that he had not renounced it. Not that he had not tendered his Canadian passport and given it up and saying that I don't want to be a Canadian citizen. But that is a convenience, albeit a wrong comparison for the MPP to, hide their shame. Otherwise, they themselves, and I'm sure even today, if law lecturers were teaching, and they were teaching on how to distinguish facts and case law, they will use the case of Adamu Sakande and Kwesen to tell them that these 2 cases are not the same, and that you need to distinguish these 2 cases as a lawyer. I'm very confident that is what is happening at the law faculty. But on radio, on television, people are allowed to loosely make those comparisons. The 2 cases are not the same. The 2 cases are, and if you look at how even the prosecution is struggling with their discoveries and how the first prosecution witness is not even answering the questions, nobody would tell you that there is no merit in that case. And they should not find a very convenient way of saying that this is the same case as Adamu Sakande, because they aren't.
I know you have expressed a disagreement with the Supreme Court on the substantive ruling, on a substantive judgment, actually. This appeal of the Domahini, is this something you agree with? I
totally agree with, because you see, if you look at what Mr. Creighton is doing for the people of Asino, he ought to be allowed to have the peace of mind, the time to develop his people. Because I don't even understand the logic of the NPP. When there is a development in a community under your tenure as a government, you can conveniently take the credit. A typical example was the AstroTurf. If you check the Parliamentary Hands Act, that AstroTurf was advocated for by Mr. Creighton. In fact, they were given MPs some developmental projects, and he chose the AstroTurf for the people of Asino because that was the demand of the youth at the time. What did the government do? The government conveniently arrogated to itself that project because, of course, it was funded by government. So if you allow the man to work, engage in his parliamentary advocacy, raise very germane questions, you would even conveniently use him to campaign in your 2024 election. So it is in your interest. And especially when you went to Asino to plaster almost every uncompleted building you saw, donate cement to almost every community that needed cement, including those that didn't need cement. You shared cloth and money for people. You shared fertilizer, Wellington boots. You gave people 200 cities of the election day, and they still voted against you. You are better off allowing the man to work. Otherwise, he has every justification as to why he cannot fulfill the promises he gave to the people in 2024. They will vote for him again. So if the government were any serious government, they will be allowing Mr. Creighton to work so that they will say that, oh, he claimed that we did not allow him to work. That is why he could not do ABC. Now we are allowing him to work. But if you are not doing that, don't you think that 2024 is still an easy pass for Honorable Creighton?
But the Attorney General says the suggestion is unhealthy.
As for that Attorney General, the least said about him, the better. You see, Godfred Dame is not fit for the office of Attorney General. He does not have the emotional intelligence that an Attorney General needs in the Republic. He has not come to the realization that when you are an Attorney General, you cease to be a party foot soldier and you ought to act like an Attorney General. And consistently, I don't know whether it's a matter of youthful exuberance or sheer incompetence. I really can't tell the difference. But Godfred Dame must realize that whether MPP or NDC, many Attorney Generals that have come and occupied that office have occupied it with grace, with honor, with the courtesy, and with what the dictate of LI 613 demanded. Because if you look at who an Attorney General should be, the Attorney General must be interested in justice, and justice does not mean conviction. So that if at the outcome of a case, the person is acquitted and discharged, to the Attorney General, he would have discharged his duty because he did not put an innocent person behind bars. That is what an Attorney General does. But the Attorney General, this Godfred Dame kind of Attorney General, is the first person to say that, like Adamu Sakande, Mr. Creighton will go to jail. He, in very serious jurisdiction, should be behind bars for those contemptuous statements he made. So how then does he turn round to come and accuse somebody who has said that he should enter a nolle prosequi? This time, the comment is not even directed at the court. The comment is directed at your office, or he thinks it's above the court. Godfred Dame should get over himself. He should know that people who have occupied the position have done better. He should know that before he came into office, nobody, reduced the office to a joke like he's doing. He should know that the Attorney General is the leader of the bar. And as a leader of the bar, he ought to carry some grace, aura, and honor. So that when he speaks, and he must speak sparingly, then people listen. Because When the Attorney General sparingly speaks, it means that anytime he spoke, it means that there is something very serious that everybody should consider. But Godfrey Dami has become like a serial texter, like a radio communicator, ready for the media than the court, ready to spew anything he wishes to spew to satisfy his party base, even if it brings dishonor to the office of the Attorney General. So as for Godfrey Dami, the least said about him, the better. Hey, Godfrey Dami, what kind of special advocacy did he have at the bar before he became an Attorney General? How many cases did he win that all of a sudden he thinks that by being an Attorney General, he will win every case, including determining outcomes of criminal proceedings? He should stop talking and we will stop listening.